suppose I'd like to have some introduction to this class. What are your majors? Right there, Mr. Hoggs. Financial planning. How about you, Mr. New York Athletics? Accounting. You, sir?
Business management.
Business management. Okay. Up here with the sunglasses.
Construction management.
Construction management. Mr. Army in the back. Marketing. Anything else far afield from one of those? Sounds like we have business management areas, accounting, marketing, sales. Yes, ma'am. What? Speech communications. Okay. You have been a spinmeister. Huh? Okay. Anybody who thinks they've got a rather strange major for this group?
Psychology.
Psychology. Okay. Yes, ma'am. Pardon? Audio engineering. Okay. Anything else? Okay. I'm trying to put this all in context. I have a pitch, presentation. I can talk all day about the subject. I don't know how to get you the most out of it, but I usually like to start from wherever you are. So let's talk about intellectual property. What comes to mind when I say that? When I say a word like intellectual property or patents or trademarks or copyrights or trade secrets, what comes to your mind? I saw a hand. Yes, ma'am. Okay. So she thinks of patents, trademarks, and ownership and rights. Yes, ma'am.
Legal rights and ownership over, like, metaphysical technologies, ideas and concepts.
Pardon?
Legal rights and legal rights over ideas or metaphysical concepts. Things that necessarily aren't tangible.
Okay. Legal rights over ideas. Pardon me, I said yes, ma'am. Didn't mean to prejudge based on the haircut, but you can tell from mine where I came from. Other comments? Surely something comes to mind.
Well, I have a question.
Shoot.
He mentioned ideas, and as far as I know, an idea is not patentable or protectable. So at what stage does an idea truly receive protection?
Okay, so you have given us a statement and a question. He says an idea is not protectable, but when is it? How far do you have to advance your idea away from the idea before it's protectable? That's a good question, and we're going to spend a lot of our time on that one. Other comments or questions? Snide remarks? Anything? Shauna? A little range? It depends. Actually, I work for some people for free. My standard rate is $400 an hour. So, but when you've spent half your life in school, you have to make the other half pay. Other comments, questions, reactions to the term intellectual property or any of those other words I used? Anything else? Okay. That's a little less than typical reaction. One of the comments I often hear is, well, I've heard that when you have a patent, if you just change your product by 10%, you can get around a patent. So patents aren't worth pursuing. I've heard that patents are so expensive to enforce that it's not worth getting them. And comments like that. Those comments come from people who have been exposed to patent law and have not really got the facts. So let's start with a survey then. I want to really get to your question because I don't know if you're going to get, I assume this is a seminar class, no exams, pass, fail, right? Got it. We're with you. So I'm not going to talk to a test, to an exam, to good questions that I would suggest that a professor put on an exam. I'm going to instead talk to a few things that I hope you will remember. And if you do, they may pay you well. So I'm going to start with a war story. I knew a kid in college. I thought he was about my age or maybe a year younger. Turns out he was 2 or 3 years younger. He was smart enough that high school was kind of a waste for him. So he took most of his courses during high school from Utah State University. And it was there when I was a first-year student that he was in my econ class. And so we got acquainted and became friends of a sort. Turns out he was going to major in engineering, but when he got to college. And later on, at Utah State University in the engineering department, I ran into him again, and we renewed our acquaintance, and we kind of kept in touch with each other over the years. And I helped him with various matters as an engineer and in dealing with some of the companies I was with that he was dealing with. One day he came to me, bajillion years after college. I'd already had an engineering career. I'd gone back to become a patent attorney, and now I was a patent attorney. And he said, I need some help. He said, I thought I could out-innovate my competition. But he said, I spent 2 years developing a product, and they have copied it within 3 months. So, intellectual property, okay, now, people have it for different reasons. I believe the principal purpose of intellectual property is to protect your profit margin in whatever you are in. By the time we got his first patent issued, he was hemorrhaging more money. I told you what my rate is, okay? It wasn't that high back then, but accordingly, okay? He was hemorrhaging more money every month than I made in a year out of his company. He was going in the red that far. We were fortunate in that once his patent issued, I wrote what I call a press release threat letter. Yes, I speak English as a first language. I did pretty well with it. And so I wrote a letter that basically was written as a press release. We're pleased to announce we've just been granted this patent. By the way, this new product, blah, 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 blah. But all of the legal premises that you needed to know were in that letter. And we attached a copy of the patent, encouraged people to buy it from this company because they couldn't get it anywhere else. By the way, that's another principle you ought to know. Paper. I don't care what people say about a paperless society. Create paper and get it on somebody else's desk. They have to do something with it. People are scared to death to be the one who throws away important-looking paper. They can ignore an email. I didn't see it. I didn't get it. I mean, I can tell you stories about people who never got the email. But when there is paper, it sits on somebody's desk and they have to make a decision. And guess what that decision is? It's, I don't want to be responsible for throwing it away. It looks too important. And so they will pass it on and it will get attention. So I sent out a press release letter knowing that these people would have to, they'd look at that and they'd have an opinion, but they'd immediately call their lawyer and say, what does this mean? And once their lawyer saw it, they were going to have a problem. Well, guess what happened? I told you how much money he was hemorrhaging. The next day after that letter went out, so in other words, one day from my Salt Lake office to some of his customers here in Utah, they turned around, one of his customers particularly, turned around 2 semi-tractor trailer loads of the competitor's product and sent them back out the gate, back to the supplier. Of course, about another day later, we heard from that competitor screaming and yelling. And then about another day or two later, I heard from his lawyer. And here's what I told his lawyer. I said, Phil, I'm sorry, but I've done my investigation. I can read a mold. I know where those products came from. And so whatever your client tells you, you get it on paper. You get a record of what he tells you, and you get the evidence. Because everything I've said, I already have the evidence in my file. Within a week, his attorney withdrew. Within 30 days, we'd shut him down. We did him a favor. We bought his molds and set up a plant in Texas with his molds because they were infringing molds. But anyway, my point in telling you this little story is the difference for my friend, and by the way, he was a multimillionaire a few years later when we sold that company out. We built and sold, I think, 2 companies for him. The difference between hemorrhaging more money every month than I make in a year and becoming a multimillionaire and selling out your company to one of the biggest players in the business was his intellectual property portfolio. You can buy the molds, you can buy the presses, you can pay for the advertising. And I have to admit, companies like General Electric, where I worked for a number of years, they own big market share, they have reputation. It's hard to replace brick and mortar and reputation. It's really hard. But Porter Rockwell's a friend of mine, okay, for your information. My parents were told when I was in 3rd grade, this is not a brag, okay, I just want to show you something about human perception. My 1st grade teacher thought I was mentally retarded and told my mother as much. In 3rd grade, after we'd taken the California Achievement Test, the principal told my parents I was a genius. After 60-some years, I've decided they were both right. Porter Rockwell's my kind of guy. Like my wife said. She said, civilized people don't appreciate guys like Porter Rockwell. And you. I'm a little rough around the edges. I'm what you call ADD, or gifted. If we manage to navigate social relationships in school, they call us gifted. If we can't handle either one and end up in jail, they call us ADD. Okay, so you can call me whatever you want. Porter Rockwell was that kind of guy. He was a man of action, a man of decision. Okay? And one reason I'm saying that is, look, I've got 2 doctor's degrees. I've figured out the school gig. Okay? I got a master's degree and a bachelor's degree and the 2 doctorates. Not by way of brag. I'm just trying to say, I don't care what you think of yourself or what other people think of you. You can work your way and you can make it. So don't let anybody tell you you can't. Okay? And by the way, at your age, I don't necessarily say do your own thing or do what you want, because you have to be of use to people. So I spent a lot of years trying to be of use to other people until I realized what I was. And then I realized, like one of my friends had told me a decade earlier, after I got out of school, I realized I'm worth more to me than I'm worth to anybody else. And he set off to start his own business. Okay, now enough philosophy. God made men, or the way Porter Rockwell said it, God made man, or mankind. Colonel Colt made him equal. I took down my 44 Colt picture and put my 38 up there instead for copyright reasons, because I knew you were recording it. And I have the right to do certain pictures, but I can't let them be published. I haven't paid for the license. Colonel Colt made him equal. What did he mean by that? Somebody. What did he mean by that? Okay. The Colt 44 gave people equal bargaining power in an argument on the frontier. The man who was big, the man who was brutal, the man who was rich, the man who was well connected, the man who had a bigger spread, had more property, he was no longer the king. You called a man a liar, you called a man a thief, and you backed it up at the point of a gun. Why? Because thieves and liars nobody would do business with. It was that your reputation was that important. By the way, that's another principle you should remember. Nothing is as valuable as your reputation, and probably second most valuable is your contacts. The head of Propeller Inc., a computer company, said when he got laid off by Toshiba, a week after being announced as the company's Employee of the Year, top sales. He was laid off a week later. Yeah, go figure. I've been in big business. I can tell you the drill. Okay, intellectual property is the Colt 45 of the little guy. I don't want to be too dogmatic, but I'm going to be quite so. Without intellectual property, you really don't have anything. If you don't have a lot of money and a big factory, name recognition, market control, market presence, how are you going to compete with people who do? You are not General Electric. You do not have 150 acres with one building that's a half-mile long in which they make transformers, to say nothing of all the other things that surround it. Where I worked at General Electric, my first job, I worked in the materials lab there at large power. We made transformers that were so big, we made them ride about 3 to 4 inches above the rails, and there was no train car. We had 16 to 24 wheels on each end that just came in and connected to the we lifted the transformer up with a crane, connected the wheels, the transformer was the train car. And we ran them down to the coast, ran them through the Panama Canal, ran them to California, and then put them on trains to go to their destinations because there was no place in America you could ship them. We had to ship them by sea. They were that big. They were entire railroad cars, transformers the size of your house. You don't own that plant and equipment. You don't own those 6,000 employees. You don't have 100 years of experience. Literally, the building. I could look out my window at the lab, and there was a Stanley Electric Manufacturing Company printed in black and white letters from 100 years ago, from 1878. It was still there. William Stanley invented the transformer. He and Edison were butting heads. Edison thought DC, direct current, was the answer. Stanley thought alternating current was the answer. Stanley proved with the transformer that AC was the way to do it, much more efficient. Eventually Edison gave in and they joined together, Edison Manufacturing with the Edison Electric with the Stanley Manufacturing to become General Electric Company. And I looked out every day and I could see Stanley Electric Manufacturing Company on the side of the wall. So, you don't have all that plant and equipment, so what do you have? You have your mind, you have ideas, and you're absolutely right, an idea is not protectable. None. Zero, zip, nada. There's no protection whatsoever available for an idea. You must cast it as one type of intellectual property or another. Here's what they are. Okay, trade secrets. I'll start with that because we know the least about it. And a lot of people say, oh, we're not going to get a patent. We're just going to use trade secrets. Very, very difficult to protect trade secrets. What's the most famous trade secret you've ever heard of? Sir?
KFC's recipe.
What?
KFC's recipe.
KFC? Oh, that's good. I think there's one that's even more famous.
Coca-Cola.
Yes?
Coca-Cola.
Yeah, the Coca-Cola formula. Right. But those are maintained as trade secrets. Now, here is the definition of a trade secret. And by the way, if you ever want to know about trade secrets, just Google Uniform Trade Secrets Act. That's a law that was written by a bunch of professors and legislators. Model laws or uniform laws are laws that like I said, professors and legislators kind of get together, people who have a lot of time to study the law, and they say, what should the law be? And they create a model law, and then different states can adopt it or modify it, but it gives uniformity. Well, the Uniform Trade Secrets Act has been adopted by 48 or 49 states. Okay, it's either 1 or 2 states have not adopted it. I think Massachusetts or one of those hasn't adopted it, but everybody else has. And it basically states this: if there's information not generally known, which derives commercial value from the fact that it's not generally known, and it's disclosed under a duty of confidentiality, then any breach of that duty is actionable at law. You can sue. Let me tell you what's good about the Uniform Trade Secrets Act. If you have information that's not generally known, and it has commercial value because it's not generally known, and you disclose it under a duty of confidentiality, And the way the law reads, it says, under circumstances giving rise to a duty of confidentiality. What's the best way you know to bind somebody to confidentiality? What would you want? Yes? Speak up, please. Okay, well, you want some leverage. You want them to have something to lose. What would it take to prove it? Paper, contract. If I can get that person's signature on a scrap of anything saying, hey, I'm giving you some confidential information, that's pretty much all you need. Now, I was involved in the litigation of one of the principal cases in trade secrets in Utah before we adopted this. And believe me, that was a tough case. That was the G&G Steel case. It was very tough because we had to go to a lot of trouble to prove that. All you need is some evidence that information was given. So, go online if you want to, find some confidentiality agreement, get one that seems reasonably fair. You don't need a lot of, I've written them 20 pages long, but I try to write them a page long so they're not intimidating. What do I want on that paper? The word confidential and a signature. That's what I want mainly. After this act, you're in pretty good shape. Now, here's where it falls down. Is keeping it secret. You normally have to document the secret, so you got to have something in writing. You need to limit the access and log the access. So you have 6 copies of this documentation maybe. Okay, and people check them in and check them out. You can't keep a secret and then have employees come in and out of the shop. You know, you hire somebody and 3 months later he's gone. You hire somebody else, 3 months later he's gone. And these people come in, don't sign anything, don't agree to confidentiality. Well, your secrets are gone. Let me tell you a very, very ugly war story. And I wish I were no part of it. Had a client come in and talk to me about an invention. Okay, medical invention. An implant for for bone surgery, orthopedic surgery, okay? Anchors and stuff like that to anchor bones together when you do surgery. So he had this bone anchor implant, and I had done a number of patents for them. So they came to me with this one, and I said, well, what did you do about the J-hook? He said, no, we're not doing that anymore. We've changed that. And I said, well, who are the inventors? He said, well, the usual bunch. I can, I'm one of the inventors, so I can explain it. No, he didn't explain it to me right. There were 2 features that they had added he never told me about. In all of the paper I got in, all of my conversations with them, there were 2 features they never told me about. You know who they did tell about them? They told their salesmen. And their salesmen told their customers, and their customers told their competitors. And before I had even written the patent, the customer had taken one of their patents, whited out a bunch of stuff, sketched in some pictures, scribbled down, and filed it. Provisional patent application. The client came back to me sometime later, and we were reviewing the portfolio because the company was being sold to one of the biggest medical equipment manufacturers in America. And as we went down the features, and he showed me the current product, I said, that feature and that feature, I've never seen them before. Well, we've been using those almost since the beginning. I said, when did you start? And I started going back and pulling the records. I started researching it to find out. And that's when I found the competitor's patent application, and I found out it was too late. And I told him candidly, I said, you know where you are? You need to sue the people who gave the information to your competitor and have the judge force the competitor to turn the patent back over to you. I have no other way to get it patented for you. The patent office is going to cite that publication against me as prior art. And I wrote an explanatory letter very candidly. So, you got to keep it secret, okay? And that's where the expense comes in trade secrets. So as long as you're alone and it's in your head, you can keep it secret. Once you get out, then how do you protect it? Back to your initial comment and question. You write it, you document it, you log it, and you control it. So that and anybody who gets access to it has to sign the duty of confidentiality. All right.
What if they don't?
You fire them.
No, what if no, I'm saying like let's say somehow they came in and just took it. Obviously they get told for stealing, but as far as trade secrets go, would they have any law
No, the law, okay, now that gets back to criminal law and also the law of torts, which says a thief has no fundamental right in the object he stole. So he does not gain any rights by theft, unless you're, never mind. I was going to talk about some governments nationwide and worldwide, but we won't talk about them. There's the law of conquest, which I guess predates our Constitution and the Magna Carta. But if you're going to deal with somebody and they need to see something in your plant and they won't sign a confidentiality agreement, kiss them goodbye. When I was at General Electric, I was on the patent committee at the division where I was as an engineering manager, and when people sent us unsolicited information, I'd wrap it up and send it right back and say, sorry, General Electric policy is we do not sign confidentiality agreements, we do not accept confidential information, file for a patent application on it, bring the patent application to us and we'll talk about it. We insisted they rely on their patent rights because General Electric was so big, we couldn't be worrying about somebody suing General Electric in Indianapolis for something that General Electric in LA received from somebody off the street. So a lot of large companies will not sign confidentiality agreements, but most people will sign them. So, comments, questions? Okay. Copyright law. This is a nasty little area of law. In fact, this little logo, the people who created it want it spread around. It's called the infinite copyright symbol. See the bow tie on Mickey. They also refer to our latest copyright modifications as the Mickey Mouse copyright law. And they mean that as a double entendre intentionally because the law has become Mickey Mouse because the law was changed to protect Mickey Mouse. Mickey Mouse was about to fall into the public domain, and somehow that just seemed un-American to a Congress that couldn't fathom that, and so they extended the copyright law by another 20 years and gave Mickey Mouse another 20 years. What this refers to, by the way, this copyright, okay, what this little infinity symbol refers to is the fact that the Constitution, and I'll talk about this a little more later, provides for copyrights and patents because there was a real source of corruption in those. It was in England, you know, our parent country back there along the way. Patents were just basically royal monopolies. Anybody in here a farmer? Nobody's raised on a farm anymore? Okay. What kind of farm? What'd you raise? Alfalfa. Did you feed it to your own animals or sell it? Okay. We raised alfalfa too. We fed it to our own animals. When I was a kid, at various times my father owned a cattle ranch, cotton, and a dairy. The king in England could give you the patent on milk. Nobody can, you know, every dairy in America has to pay you a 1% royalty in order to be in the dairy business. Why? Because the king said so. Because he wants to give you a reward. Corruption? How do you spell corruption? Copyright, same way. You can't print. That's what the stamp tax was all about. They were taking certain products and requiring you to get a government stamp on them showing that they had been taxed for somebody who wanted the money. It may have been the king or it may have been somebody else. But a patent or a copyright was a very abusive practice in Great Britain. On the other hand, like my friend in that opening story, why should he develop a new product and spend 2 years in development solving all the problems only to have some Pacific Rim knockoff come in and undercut his price? What's the incentive to improve anything? And so, in the Constitution, it makes provision for patents and copyrights, but they're only allowed to last for limited times, not forever. Copyright, life of the author plus 70, is it? I can't remember whether it's 70 or 90. One of them's, it used to be 50 and 70. I think now it's 70 and 90. The 70 is life of the author plus 70, or 90 years after it's been granted, if it's anonymous. That is, if it's owned by a publication, nobody knows who the author is, but the publication had the right because their employee made it, then those anonymously published, it's like 90 years after first publication. All right, what does it cover? Have any of you, okay, where have you seen copyright notices? Haven't heard anything from you, sir. Yes, no, right above you, in the gray jacket. Where have you, that's you. He's wearing a gray sweatshirt. So where have you seen a copyright notice? Have you seen any copyright notices? Okay, toys? At the end of movies? Where else? Okay, in books? Where else have you seen them? Music and CDs? Photography, photos that's a big deal because there's so much moving around of photos. That's why I had to redo my presentation today, because I have a limited license only. Okay. Basically, copyright protection extends to any creative expression fixed in a tangible medium. Sculpture, books, written. Any of you that are churchgoers, take a look through the hymn book. You know, almost everything. The book is copyright, intellectual reserve, but individual songs in there you'll find, you know, are copyrighted by various individuals and various foundations. No matter which church you go to, they may have borrowed the music from somebody else who's got the copyright on it. So you see it on any creative expression. And if somebody's mentioned clothes, I think, clothes, typically it's the design on the cloth, not the article of clothing. They deny copyright protection largely to clothing because it's just too hard to enforce and too hard to draw bright lines. But the patterns of the fabrics and things like that, those will often have copyrights on them. So, and by the way, everything I've said here, the thing you should know is the second line in the title block. www.loc.gov. That is the Library of Congress. Everything you ever wanted to know about copyright law, you can get from their website. It's not that complex. Well, I take it back. It's a nasty little can of worms, but that's not your problem. Getting a registration is rather straightforward. Enforcing the copyright and all that sort of thing. But let me tell you a couple of quick things you ought to know. It's not that expensive. In fact, I normally tell clients, go ahead and file for copyright yourself. I've got to charge you several $100s just for the time I've got to put into it. Go read their website. They're very friendly. If you want to call them, they'll talk to you. Everything's done in forms, and so there's no black magic in it. So just go to the Library of Congress website and get what you need. Read until you understand it. And if you don't understand it, call them, because they're very helpful. And you'll find music, writers. I don't know if you're country western or whether you're all into modern or. In fact, punk, I think, was back when I was a young adult. I don't even think that, I think that's passé or way gone by. What are they into now? Alternative rock or whatever. Bottom line is, all these people that write music, they all file their own copyrights. They file dozens and hundreds of them because they don't know which song's going to hit. And once they put it out there, somebody else may make a bigger hit out of it than they did. So what they do is they just file all these copyright applications, and they take a bunch of them and they sell that, what they call it not a portfolio, they call it a catalog. They sell that catalog of music to some either a publisher or something. And But the bottom line is, you can do it yourself, and you should do it. You can put the Circle C whether or not you have filed a registration. If you file a registration within 3 months of publication, then you can demand statutory damages. You don't have to prove how badly you were hurt. You don't have to have been hurt. But if you file for a registration within 3 months, so in other words, promptly after you publish, then you've got, you can ask for statutory damages and attorney's fees. And that will make it worth the trouble to enforce it. If you don't, then you've got to prove damages, and that's an expensive proposition, and then you've got to pay your own lawyer, and I've already explained. That's an expensive proposition. Trademarks. A trademark is a designation of origin. It can be words, it can be a logo, it can be a little jingle, some kind of music, it can be a shape of a product. There's limitations on that. To some extent, it can be color. Like if you see household insulation that's going in a wall of new construction, and the insulation is pink, where did it come from? Speak up, somebody.
Pink Panther.
Pink Panther, and who is that? And who is that logo? Owens Corning. Yeah, they had to fight that one all the way up the court system, because normally you can't normally use take a whole color. Morton Salt lost their lawsuit all the way up the chain of the Supreme Court. They tried to trademark that bright yellow for salt. And they said, no, there are only 3 primary colors. You're not going to get to own one of them. But the reason why Owens Corning got it is because that insulation had no need of color. There was no need for it, and the color they picked was absolutely arbitrary and did not remove any ability of their competitors to compete. And so, Big Pink, the Pink Panther, Owens Corning, everybody knows. So, you can trademark colors, but normally you don't normally get just a single color. You have a color scheme and that sort of thing. By the way, who owns those 2 trademarks? Coca-Cola. Do you know how much that trademark is valued at? Read it and weep. $42 billion. That's what it shows up on their books, and everybody considers that an undervalued, that's a low value compared to what it's really worth. Again, words, logo, music, shapes, colors, names. By the way, trademarks are not limited time. You can renew them forever. Copyrights and patents last for limited times. Constitutionally, they're provided for. Constitutionally, they must be limited. Trademarks can last forever. You renew them every 10 years. Actually, you have to renew them at 5, then at 10, and then every 10. Yes, sir?
How difficult are they to do on your own?
Trademarks?
Yeah.
Not bad once you understand the principles.
Okay.
Um,
But more difficult than copy.
if you're interested in knowing, you might want to write these things down, because you will be fighting, all of you will be fighting with your advertising departments and with your salesmen. They always want, classic case was the chocolate soda case. A company wanted to trademark the name chocolate soda. And they said, no, that's the generic name. No, it's not generic. Nobody ever came up with chocolate flavored soda before. They said, yes, but whenever somebody does want to copy you and use chocolate soda, what are they going to call it? Chocolate pop, chocolate soda. They're going to need the name chocolate soda. That's a generic expression. That's like water. That's like milk. That's like juice. It's soda. It's chocolate flavored soda. They lost all the way through. Well, they finally got a brain, and they named it Choco Fizz, which moves it out of generic up to kind of suggestive. Choco Fizz. Yeah, it suggests that it's carbonated and that it's chocolate flavored, but it's not chocolate soda. I saw a bottle of that. I bought it. I keep that in my office because that's a legendary case. Tastes horrible. But anyway, so here are the things you want to know about trademarks. Okay, first of all, what it is, it's a designation of origin. There are 5 levels of strength. Okay, and they are, the strongest mark is what they call fanciful. Fanciful is Exxon. It means nothing. It has no meaning except the meaning that advertising gave it. Okay, that's the best example I know of, fanciful. Okay, the next is arbitrary. Apple for computers. Arbitrary. What do apples and computers have to do with each other? Absolutely nothing. So it's an arbitrary application of the name. So Apple computer is an arbitrary mark, second strongest. Third is suggestive. That is like crystal for spring water. It suggests a property. Choco Fizz is a good one for suggestive. Okay? It suggests some property, but it's not literal. Okay, the next 2 levels are descriptive, which is like Rocky Mountain spring water. Sorry, you can't have it. That's just a geographic description of where it came from. Okay, so you can't have that if it's merely descriptive. And the last is generic. That's like water, milk, chocolate, soda. Okay? Remember that, because your salesmen always want to go to the bottom. They always want the generic description. They want that for your mark. Like there's somebody out here, you might hear them on the radio, the advocates. They can never register that mark. Attorney is French for advocate. So these people who advertise themselves as a law firm, as the advocates, you don't need a lawyer, you need an advocate. Excuse me, that's redundant. So they can't register that mark because it's just a generic description. That's what we are. We're advocates. We represent somebody to somebody else. So those are the 5 strengths of marks. Keep yours in the top 3. Okay, there's another point I wanted to make, but I'm not going to make it because I forgot what it was. My mind moved on. Okay, patents. Here's what you can patent. Structures, methods, and designs. I didn't put plants on there. If you propagate plants from cuttings, there are protections available. You know, the russet potato, there's some burpee seeds, the Elliott apple, the Burbank apple, you know, anyway. There are some plant. I've never had run into it in 25 years of patent law. If I need it, I'll go look it up again. But mainly it's structures and methods. Now I'm going to mention designs because you need to know about that. You'll find the shapes of things, the ornamental appearance, those are highly protectable. It's not too expensive, and there was a time when I didn't think they were all that useful because the protection's kind of narrow. What's covered is what's shown in the pictures, and the pictures show exactly this thing. They show you maybe a couple of perspective views, and then they show you the top plan, bottom plan, front elevation, rear elevation, left side elevation, right side elevation. And basically they say, I claim this invention. So you got a different shape of a coffee cup or a different, I've got a bunch of patents on clothing. Okay, back to the point somebody was raising about copyrights on clothing. I've got design patents on some articles of clothing for clients. Light fixtures and stuff like that, and electrical fixtures, dozens of patents on those for clients. Yeah, you look at that and you say, what? Wall panel for an electrical, what? Yeah, we have design patents on a bunch of those. Slight differences. So the design is the ornamental appearance. Most of patent law is in the other two areas, structures and methods. Structures, the guts of this little machine, suspension systems on vehicles, drill heads on petroleum drilling rigs. I've written patents on that. Sewage treatment systems. I've written patents on that. It's a dirty job, but somebody's got to do it. That's where I learned about eductors. I guess I should have, we didn't study them much in engineering, but have you ever thought about how hard it is to pump sewage? Well, it's done with eductors. I've written patents on those. So, trade secrets, copyrights, trademarks, patents. And I'm probably out of time, and then some. So, no, not then some.